Hi, everyone. My name is Susan Blissett. I am a law clerk at Community Legal Aid Society, and I work in the Medical Legal Partnership Unit. Today, I'm going to be speaking with you about custody in Delaware and how to file for it. You can find the custody forms on the Delaware Court website. If you go to the Delaware Court's website, you can click on a drop down on the top left of the homepage and select Family Court. From that page, you can scroll down and click on the Forms button under the Custody section, and you will be taken to a page where you can download, fill out, and print all of the custody forms to file with the court. In addition to that, you may want to pause the video or rewind it as you need to listen to something I said again. Please feel free to do that. And also, please feel free to skip ahead to parts that are most important for you to watch. If you would like to skip ahead to the part of the video where we talk about what forms you need and how to fill them out, that information can be found starting on slide 19. A note about the custody forms: you should try to fill them out to the best of your ability as accurately and completely as possible. So what is family court? Family court is a court that hears adult criminal cases and civil cases, which are non-criminal cases. Those include protection from abuse, custody, divorce, and other cases related to families. Another big question that we'd like to answer is, what is custody? In the state of Delaware, child custody refers to the parenting arrangement between two parents and the children that they have together. Custody includes things like where a child lives, how each parent has contact with the child, each parent's access to information about the child, and each parent's ability to make important life decisions about the child. There are two main types of custody. Those are physical custody and legal custody. Physical custody refers to where the child lives most of the time and which parent has actual physical possession and control of the child. Legal custody, on the other hand, is the right to make major life decisions for the child, including medical, religious, and educational decisions. There are two types of legal custody. They are called joint legal custody and sole legal custody. Joint legal custody means that the parents must confer and make decisions with each other regarding major life decisions about their child. Sole legal custody means that one parent makes those decisions without consulting the other parent. A note about legal custody: both parents are always entitled to information about the child, regardless of whether there is joint or sole custody. Another question we'd like to answer is, what is visitation? When you file a custody petition, the court will determine whether the parents will share custody or which parent the child will live with most of the time. If custody is not shared, the other parent will be given a visitation schedule. This visitation schedule allows the child to have frequent and meaningful contact with both parents. There are 5 main steps in the custody and visitation process, and I'm going to take you through them now. The first step is that one parent files a custody petition. This is the paperwork that begins the custody case. We will go over the forms that you must fill out and file with the court to start a custody case later in this presentation. As a note, you will see this language on most of the custody forms where one party is referred to as a petitioner and the other party is referred to as a respondent. The parent who files the custody petition first is the petitioner, and the parent who responds to the custody petition is the respondent. The custody process also includes paying a filing fee of $100. If you are unable to pay the filing fee, you may submit a form called an Affidavit in Support of Application to Proceed in Forma Pauperis. Submitting this form, along with proof of your income, for example, pay stubs, is your way of showing that you are unable to pay the court fees and costs for filing for custody. A note: this form will ask you questions about employment, income, property, debt, and the reason that you are requesting the fees are waived. Other steps you should take when filing for custody. You must file the forms at the courthouse. When you arrive at the courthouse, you will go to the prothonotari's office inside and tell the person at the front, the clerk, that you are filing for custody. If you need to have any documents notarized, you will do so at this time. You will need at least one original of the forms that you have filled out and 2 copies. The court will keep the original and one of your copies. The second copy will be for you to keep for your own personal records. The second step in the custody process is that the respondent must be notified that a case has been started by the petitioner. The respondent is notified by being served with a copy of the documents the petitioner filed with the court. The parent who did not file the paperwork to start the case has 20 days from being informed of the case to file an answer with the court. Step 3. Both parents must complete a parent education class within 6 months if the child or children are under 17 years old. If the class is not completed, or there is no certificate of completion filed with the court within 6 months of the initial date the custody papers were filed, the case will be dismissed. If the case is dismissed, the process will need to be restarted by filing a new petition to obtain a custody order. After this is done, your case will typically go to mediation. Mediation is a less formal meeting for the parties to come together and negotiate custody. If mediation is successful, the parties are agreeing to follow the order that they determined in mediation. A note about mediation: if there is domestic violence and a protection from abuse order is in place, the case is scheduled for a hearing before the judge and there's no mediation scheduled. Step 4, the case is scheduled before a judge. Step 5, if there is no mediation or no agreement at mediation, the case will be assigned to a judge. The judge will typically schedule a case management conference, which may be by phone, Zoom, or in person. The purpose of the case management conference is to make the judge aware of the status of the case and to schedule the case for a custody hearing. At the custody hearing, both sides will have the opportunity to present witnesses and evidence. The judge will then make a decision based on the information presented and issue an order. Next, we're going to go over the things that the court considers when determining custody. To make a decision about custody, the court considers the best interest factors. The focus of your witness and evidence should be on these factors. I will now go over them. The best interests of the child factors include the wishes of the parents as to the custody and placement of the child, the wishes of the child as to the custody and placement of the child, the interaction and relationship of the child with the family and important people to the child, the child's adjustment to their home, their school, and their community, the child's mental and physical health, as well as the parent's mental and physical health, past and present compliance with rights and responsibilities of parents. And the final two factors are any evidence of domestic violence or criminal history of all in the household and the parties. A visitation order may be modified at any time if the best interests of the child would be served by the modification. A consent order, temporary order, or a written agreement between the parties may also be modified at any time if the best interest factors of the child would be served by the modification. An order entered by the court after a full hearing or contested hearing concerning legal custody or primary residence may be modified as follows. If it is within 2 years of the most recent order, and only if the courts find after a hearing that continuing enforcement of the prior order may endanger the child's physical health or significantly impair their emotional development. If it has been more than 2 years since the most recent order, the court may modify after considering whether any harm to the child by a modification, and if harm may be outweighed by the advantages to the child of modification, the compliance of each parent with prior orders, and the best interest factors. There are a few other helpful tips that we are going to provide you when you file for custody. First of all, you should try to complete the parent education class right away. Failure to complete the class or complete it on time can result in your case being dismissed. In addition, the classes fill up quickly, so sign up right away. Finally, earlier we discussed evidence that you may want to bring to a hearing. You should save all communications with the other parent. If there is a court hearing, the other side could request this evidence, or you may want to use it as your own evidence during the hearing. Examples of communications that you should save include text, emails, videos, letters, and photos. So how do you know if you need to file for custody? If there is no family court order, then both parents have the same legal rights to have time with the child and make decisions about the child. If parents agree on major life decisions, where the child lives most of the time, and they work reasonably well to meet the child's needs, a court order may not be necessary. Law enforcement generally will not be involved in a child custody dispute when there's no court order, unless a crime has taken place. So this is the part of the presentation where we are going to go over what forms you need to file for custody. There are some forms that are required and others that are situational. The first forms that we're going to go over are those that are required for everyone who is filing for custody. After that, we will go over a few of the more common situational forms and how to fill those out. So what forms do you need to file? The first form is the petition for custody. This is labeled Form 345. The second form that you need to file is the custody separate statement. This is Form 346. The third form that you need to fill out and submit is the information sheet. This is also known as Form 240. And then the final form that you must fill out is the custody, visitation, and guardianship disclosure reports. This is known as Form 364. Form 364 must be submitted prior to the mediation or the hearing, whichever comes first in your case. Thus, we suggest that you fill out and submit that form with all of the others so that it is already taken care of. Here are some of the situational forms. The first is an affidavit of unknown address. This form you use if you do not know the address of the other party. The next form is a consent order. That is Form 349. This form you will use if you and the other party have come to an agreement on your own and you would like to submit that consent order to the court to approve. Finally, Forms 405 and Form 420 relate to military service. These are less frequently used forms, and you can read their descriptions on the court's website to determine whether you need to fill those out. Here is an image of the first page of the petition for custody, also known as Form 345. We are now going to go over how you fill this form out. As I mentioned before, please feel free to pause the video or rewind it as you need to follow the instructions. Filing a petition for custody at the courthouse will start the custody process. As we discussed earlier, the respondent will have 20 days after being served with your petition to respond. To fill out the form, check off the box on the top that marks the county in Delaware in which you are filing for custody. Custody should be filed in the family court in the county in which the child lives. Under the petitioner column on the form, fill out your information. On the respondent column, fill out the other parent's information. A note about these forms. You should leave the boxes marked file number and petition number empty. The court will assign these numbers after they receive your documents. As we make our way down the form, you should check the appropriate box for whether this matter is related to a federal immigration case. The next step on the form is to write the full legal name and date of birth of each child that will be covered by your filing. In the following lines, you should fill out the names of the person the children live with, your and that person's relationship to the children, and the street address, city, state, and zip code of that residence. The final question on the petition for custody is your chance to state the specific type of custody you are requesting. You should also explain to the court why you are filing for custody and why you think that the court should grant you the type of custody that you are asking for. You should consider including information like where the child lives most of the time, how much time the child spends with each parent, and which parent or parents make important decisions for each child. Finally, you will need to make sure you are in the presence of either a court clerk or notary to sign this document. The Prothonotary's office in the courthouse, where you will be filing these forms, will have a notary who you can sign the forms in front of. If you are unable to sign the forms in the presence of a court clerk or a notary, you can presently use an unsworn declaration form instead. The next form we're going to discuss is the custody separate statement. This is Form 346. The custody separate statement explains to the judge where and with whom your children are currently living and where and with whom they've lived in the past. To fill out this form, once again, start by choosing the appropriate county in the state of Delaware in which you are filing for custody. Put your name in the line marked petitioner and the other parent's name in the line marked respondent. A note here: sometimes the respondent will not be another parent. Respondents can be any guardian of the child or the person with whom the child is living, a guardian ad litem of the child, or any organization having custody of the child. An example of an organization like this is the Division of Family Services. The custody separate statement should then list what kind of petition you are filing. For example, you could be filing a petition for custody or a petition to modify custody. Next on the form, list the children named in your petition, including the date of birth, city, and state of birth for each child. Choose yes or no to whether all your children have lived together throughout the last 5 years. If the answer to this question is no, you will need to get another copy of this form for each of your children and fill it out for each child. The next step is to fill out the information about where your child currently lives. You should list the requested information for each of the people who live at this location with your child. For the second block of information, fill out where the child has lived during the past 5 years. If the child is less than 5 years old, end with the first address where the child lived. You should also describe who else has custody or visitation with the children besides you and the other parent. You should also describe any other custody cases that you have been involved in. You should check the appropriate box if there are any other types of court cases your family is involved in that could impact your custody case. If you check yes to this question, follow the instructions to provide more information to the court. Once again, when you are completed filling out this form, you will need to make sure you sign it either in the presence of a court clerk or a notary. You can find these people at the courthouse in the Prothonotary's office when you file the forms. Once again, if you are unable to sign the forms in the presence of a court clerk or notary, you can presently use an unsworn declaration form instead. The next required form we are going to discuss is the information sheet, also known as Form 240. The information sheet allows the court to see personal information about you and the other party. You must fill out a court information form for all cases filed with the court. It will ask you, the petitioner, to identify the respondent and to provide other identifying information about both of you. To complete this form, begin by filling out the requested employment and personal information about yourself. In the appropriate box, describe your children by providing the requested information. Next, fill out the requested information about the other parent. In the following boxes on the form, provide any additional information about the other parent that may help the process server in locating them to serve the petition. This can include directions to the other parent's residence. The final required form that we are going to discuss today is the Custody, Visitation, and Guardianship Disclosure Report. The court recommends that this form is completed and filed with the custody petition. As we mentioned earlier, if you do not file this form with the petition, you must complete it and exchange it with the other party at least 7 days prior to a mediation or hearing, whichever comes first in your case. To start filling out this form, once again, choose the box that marks which county in Delaware you are filing for custody. Next, fill out the information about yourself that the form asks for. After you have done that, fill out the following lines on the form with the requested information about the children you are applying for custody for and the other residents in your home. Next, answer the following question by explaining the current contact schedule you have with the children. And then select the type of schedule you are requesting and describe the visitation schedule you are requesting. After reading the description of legal custody, select the type of custody you are requesting. If you are requesting sole custody, you will need to explain why you would like that type of custody. In the following spaces, answer the questions regarding your work schedule, your location, and the school district in which you live. Then you should provide the information requested about your health and the other parent's health. Finally, list the requested information about your criminal history and the other parent's criminal history in the following lines. You should also answer the questions about domestic violence and child welfare. In addition, fill out the requested information if the children have ever lived with anyone other than you or the other parent. Finally, like the previous forms, you will need to sign this form in the presence of a court clerk or a notary. You will also need to fill out and sign the Affidavit of Exchange at the bottom of this form in the presence of a notary. Once again, if you are unable to sign the form in the presence of a court clerk or notary, you can currently use an unsworn declaration form instead. We will begin discussing some of the situational forms that are used most often. The Affidavit of Unknown Address, also known as Form 241, is used to determine where a respondent lives. You should use this form if you do not know and cannot locate the address of the other party. The other situational form that we will go over today is the Consent Order Custody form, also known as Form 349. The consent order form will be filed if you and the other parent agree on a custody or visitation arrangement. If you and the other parent can agree on a custody schedule without a formal hearing, you may use this form to file that schedule with the court. A voluntary, mutually agreed upon custody schedule will be presented to the court, and if the court agrees with the proposed schedule, the court will issue a consent order. To fill out this form, choose the county in Delaware in which you are applying for custody. Fill out your information on the petitioner side of the form and the other parent's information on the respondent side of the form. After you have done this, fill out the names and dates of birth of the children you're applying for custody on behalf of. You should then describe the type of custody you and the other parent have agreed upon in the following lines by providing the information that is requested of you. In the next section, you should describe the visitation schedule you and the other parent have worked out. Be as specific as you can in this description. Explain the places, dates, and times that visitation will occur, as well as who is responsible for transporting the children to and from the visits. Finally, both parties will need to sign this agreement in the presence of a court clerk or notary. You will be able to sign this form with the other party at the Prothonotari's office and then file it there.